Every day in the USA, people find themselves in court.
Oh, nope. Court does call the case, People State of Michigan versus Patrick Thorn.
Assistant Prosecuting Attorney Morgan Baroque on behalf of the people.
And the Assistant Public Defender on behalf of Mr. Thorn, who's present. Mr. Thorn, state your name for the record, please.
Thank you. All right. Date and time set for preliminary examination. Are we ready to proceed?
Yes.
Yes, Your Honor.
All right. You may proceed.
Our first and only witness is going to be Officer Naomi Smith.
Let's come forward to be sworn.
Raise your right hand. Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? See, state your first and last name and spell it for the record.
Naomi Smith, MAOMMITH.
May inquire.
Thank you. Good morning, officer. Thank you so much for being here. Can you tell me what you do for a living?
I'm a police
And where are you a police officer?
the city of Thorn,
Are you with a particular agency?
the Ypsilanti Police Department,
Okay. And how long have you been employed there?
4 years.
I'd like to direct your attention to November 30th, 2023. Were you working that day?
Yes.
What shift?
A 8-day shift,
Eh.
6 a.m. to 6 p.m.
Okay. Were you in a marked patrol car? And were you in uniform on that day? Were you dispatched to a 545 South Huron Street in Ypsilanti, Michigan, in Washtenaw County at that time?
4 or 5.
I'm so sorry. You are correct. 454.
Yes, I was.
Thank you. Can you tell me what was the nature of this dispatch?
A domestic assault had occurred.
Did you arrive on scene?
Yes, ma'am.
And who did you encounter when you arrived on scene?
When I arrived on scene, I was flagged out by a lady who identified herself as Maya Graham.
Zakiah Graham. Would you recognize a Patrick Thorns today if you saw him?
Yes, ma'am.
Is he in the courtroom? Can you briefly describe where he's sitting and something he's wearing?
He's sitting at the table wearing a green t-shirt.
Your Honor, please let the record reflect that the witness has made an in-court identification of the defendant.
Without objection, record shall so reflect.
Do you happen to know the relationship between the defendant and Miss Graham? What is the nature of that relationship?
Ms. Graham and I, they have been on again, off again, significant others for 3 years.
And how do you know that?
Ms. Graham advised that to me
Okay. So you spoke to Miss Graham, presumably more than just that.
while on scene.
Okay. And did she say why she flagged you down?
Yes, Ms. Graham advised that she was at the location sitting in her friend's vehicle when her on again, off again boyfriend, Mr. Thorns, saw her and approached her. Ms. Graham advised at that time, he got out of his vehicle and began yelling at her about money that she owed him.
I just want to be clear about this. When you say her, being yelling at her, that was Miss Graham, not the friend?
Correct.
Okay. Thank you.
Ms. Graham then stated that Mr. Thorns continued to yell at her about money that was owed to him. At which point he then hit her in the face with a closed fist. And then continued to yell at her about money being owed to him. And then Mr. Thorns then grabbed her cell phone and.
Hearsay.
Your Honor, at this point, I would say that this is admissible under 76827C. If Your Honor wants to hold, because this is a domestic violence situation, if Your Honor wants to hold your ruling on this objection.
This is as to the phone that you're objecting?
Yes, sir. 768.27 allows hearsay to be admissible to describe the infliction or threat of physical injury on the declarant, not theft.
But I think it's been held to go to the entire domestic violence case, but okay, I'll hold the ruling on it.
Your Honor, and just briefly in response, under People v. Only, it is our understanding that 27C does encompass the entirety of a domestic violence situation, not simply physical harm.
Yes, that's the court's understanding also, but I'll hold the ruling on that.
Thank you. You were saying something about a phone.
Yes, Ms. Graham advised that during the physical altercation, Mr. Thorns grabbed her phone and grabbed a pack of cigarettes, causing several of her fingernails to get broken and her fingernails were bleeding.
Did you happen to observe any injuries?
Yes, I observed her fingernails that were broken and bloody and blood on her face.
Were there any photos taken of these injuries that you observed?
Yes, on scene, I took photos of her injuries.
If you saw those photos today, would you recognize them? Yeah, Your Honor, may I approach?
You may.
Please let the record reflect that I approached the witness with People's Proposed Exhibits 1 through 3. Looking at People's Proposed Exhibit number 1, do you recognize it?
Yes, ma'am.
Is that a fair and accurate representation of one of the injuries that you observed on Miss Graham on November 30th, 2023? Can you briefly describe what you see?
Yes, there's a hand in the picture with purple nails and the thumb, it has a bunch of blood on it and the nail is broken.
Your Honor, the people move to admit People's Proposed Exhibit number 1.
Any objection or voir dire?
None for purposes of examination.
Exhibit 1 is admitted.
Moving on to People's Proposed Exhibit number 2, is that a fair and accurate representation of some of the injuries that you observed on Miss Graham on November 30th, 2023? Can you briefly describe to me what you see in that photo?
Yes, and again, purple nails and 2 fingernails are broken. And there's also a cut to the thumb.
And whose hand does that belong to? Your Honor, the people move to admit People's Proposed Exhibit number 2.
Objection or voir dire?
No objection or voir dire for purposes of exam.
Exhibit 2 is admitted.
And then finally, looking at People's Proposed Exhibit number 3, is that a fair and accurate representation of what you observed on Miss Graham's face on November 30th, 2023? Can you briefly describe what you see in the photo?
Yep, it's Miss Graham's face, and her eyes closed, and you can see there's blood on her eyelid. There's a mark above her left eyebrow and a mark on her left cheek.
Your Honor, the people move to admit People's Proposed Exhibit number 3.
Objection or voir dire?
None for purposes of exam.
Exhibit 3 is admitted.
No further questions at this time, Your Honor.
Cross-examination.
Thank you. Officer, you spoke to Ms. Graham. She described an off again, on again relationship with Mr. Thorns. How frequently were they together?
About 3 years.
How frequently? How often did they see each other? What did they do when they saw each other? What was the nature of that relationship then? Dating? How frequently though?
Throughout 3 years.
Throughout 3 years, but that's a length of time. That's not frequency. How frequently?
You asked already, and I did not ask that.
So you don't know?
Correct.
Okay. Were they exclusive with each other?
Ms. Graham advised that he had a wife.
So that'd be a no.
Correct.
Was she exclusive with him? Ms. Graham exclusive with Mr. Thorns?
I-
You don't know. Was there an expectation of affectional involvement in the relationship? You said you observed injuries to Ms. Graham. Is that correct?
Yes.
Did you observe injuries to her face? What injuries did you observe to her face?
There was a pink mark right here under her cheek or on her cheek, and there was a mark right below her eyebrow.
So there were 2 marks. Okay. Was she bleeding in the face?
There was blood on her face.
Was she bleeding from the face?
Do not recall.
Okay, because she was bleeding from her fingertips, right?
Correct.
So there was blood on her face, correct? But that could have come from her fingertips. So you don't know. Did she receive medical attention?
She refused medical attention.
Okay, so nobody came and actually medically observed her injuries
Correct.
or assessed them. The injuries to her fingernails, those could have been offensive injuries, correct?
I do not.
You don't know?
Correct.
So when you say you don't know if they could have been, or you,
Objection to speculation. They could have been anything, counsel.
good enough for me, Judge. Have you ever seen Mr. Thorns before today?
In a photograph, yes.
And where did you see that photograph?
Secretary of State,
And under what circumstances did you look at that photograph?
walking directly to this investigation.
Okay, so when you ID'd him based on a photograph.
Correct.
You didn't personally observe Mr. Thorns in your investigation.
He was not on the scene at the time of my investigation.
So no,
Correct.
and you haven't interviewed him about it.
I spoke to him on the phone,
Okay, but you didn't personally observe him.
not in person, correct.
And when you spoke to him on the phone, he denied assaulting Ms. Graham.
Correct.
Judge, if I could have just a moment. When you spoke with Mr. Thorns, did he cooperate with you?
Yes.
And he told you he would cooperate with whatever you needed? No further questions, Judge.
Any redirect?
Only one question. Did Miss Graham happen to indicate whether or not any of the injuries she had were from prior to this incident?
No.
I'm sorry, can you clarify?
She indicated the injuries that she showed me were from that incident when I got called there.
Okay, thank you.
All right. You may step down. Thank you. Any additional witnesses for the people?
No, Your Honor.
Any witnesses for the defense?
No, Your
Have a motion?
Yes, Your Honor, the people move to bind over on count 1. At this point, we have heard testimony from Officer Naomi Smith as to the allegations on November 30th, 2023. The people believe that they are admissible under 768.27C. We provided corroborating evidence in the form of 3 photos documenting injuries described in the police report, including broken nails, bleeding from her hands, bruising and cuts on her face, as well as blood on the victim's face. So the officer testified as to the events as understood by the victim on November 30th, 2023, and identified Mr. Thorns through her exposure to him, which was through a photograph.
Thank you. Response.
Your Honor, I would object first of all on the admissibility of the statements with regard to 768.27C. First of all, the statements need to be admitted. In order for them to be admitted, it has to involve domestic violence. And to involve domestic violence, there has to be a dating relationship. And as used in that statute, dating relationship means frequent intimate associations primarily characterized by the expectation of affectional involvement. The witness specifically testified she didn't know if any of that was true. It was an on-again, off-again relationship. The statute specifically states that it does not include a casual relationship. She could not testify as to whether this was a casual relationship or an actual dating relationship. She could not testify as to frequency, and she could not testify as to intimate associations, and nor could she testify to whether there was an expectation of affectional involvement. That's what the statute requires. She could not lay the foundation for that. So I would argue that 768.27C does not allow the hearsay testimony to be admissible. Further, in order for it to be admissible, even if the court were to find that it was a dating relationship, the statement needs to be made under circumstances that would indicate the statement's trustworthiness. First of all, as the court stated, the injuries to the fingers could come from anywhere. There's not a single thing that is offered.
Well, the court didn't state that. The court was noting the objection based upon your question to speculation. Whether you took it that way, counsel, is your business. That is not what the court stated.
Very well. But regardless, Your Honor, those pictures do not prove anything to do with Mr. Thorn's. They don't suggest that he was there. There's no evidence to prove that he was there. There's no independent evidence to support the fact that he was there. There's evidence to support that there were broken fingernails and blood on her face. That does not actually indicate the statement's trustworthiness. Additionally, one of the things that the statute requires the court consider is whether the client has a bias or motive for fabricating the statement and any extent of any bias or motive. And there is testimony that this woman was in some sort of relationship, maybe casual, we don't know, with a married man. So that in and of itself can create biases that a person might have to lie. We don't know what her biases may or may not be because she's not here. And if she doesn't come to court to testify, then we are limited in the information that we have. But in order to admit the statements under this exception, the court has to make those findings. And I would argue that under these circumstances, the state has failed to establish what it needs to get over the hearsay objection. So I would argue that the court should not consider those hearsay statements, but if the court does consider them, it is still up to the court to determine what weight to give them. And I would argue that any weight given to them would be insufficient to establish probable cause. So the defense would ask the court to dismiss the charges today.
Response.
Your Honor, I appreciate counsel's attention to the specific language in the statute, but I do think counter to his point is the fact that the victim herself described it as a dating relationship. It took place over 3 years. At that point, taking her at her word, she was intimate with defendant. I don't think we can help or blame a person for not using the specific legalese outlined in a statute when describing the nature of their relationship to law enforcement after they have been assaulted and are still on scene with injuries. As far as the injuries in particular, we have testimony from the officer outlining that these injuries were not from any incident prior to the victim's involvement with the defendant. And we have the victim's account of what happened where she was approached by the defendant was verbally berating her, and then the defendant escalated the situation by punching her once with a closed fist, and then further exacerbating it by taking her phone, leaving her with broken nails and additional cuts on her hands. At this point, I think that we meet all of the necessary requirements for 27C, including and especially the nature of the relationship.
Court believes that the people have indeed established in terms of whether or not this fits under a domestic violence circumstance, the testimony of the officer and description of the relationship, I think certainly does fall within the confines of that particular statute, an exception to the hearsay rule. So to the extent the objection is based upon the fact that this is not a domestic violence circumstance because of the relationship, the court doesn't find that persuasive at all and believes that the people have indeed shown that. The specifics of how people are involved in different relationships may not always be known, and then it's not going to speculate. What is clear is that they had an on and off again relationship for a period of over 3 years. So as to that, as to whether or not also the statements should be admitted, statements of Ms. Graham, the court does find that they should be admitted and should be taken into account by the court. They're backed up and they're corroborated by the injuries as described by the officer. In this case, in responding to Ms. Graham, it is in retrospect temporally related to what she described as to the events which occurred at the hands of Mr. Thorns. And so court does find that the statements are trustworthy. Further, the court does find, based upon the corroboration of the injuries to what Ms. Graham had described, the court gives those great weight with reference to this particular offense. So for those reasons, and noting that the court doesn't believe any of the objections stated by the defense, the court would then bind the defendant over to the circuit court to stand trial on this charge.
Your Honor, defense would acknowledge receipt of the information. We waive its formal reading. My client would stand mute as to the allegations and he would demand a speedy trial.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
April 8th at 1:30 before Judge Slade Monday.
April 8th.
Yes.
April 8th, 2024, 1:30, Judge Slay, Monday. Bond continued. Thank you.